From the opinion pages of the Wall Street Journal, this is Potomac Watch.
The Supreme Court declines to save TikTok, ruling against the social media app's challenge to a law saying that it must be divested from Chinese ownership or banned from U.S. app stores. But what ultimately happens now seems to be up to one Donald J. Trump. Welcome, I'm Kyle Peterson with the Wall Street Journal. We're joined today by my colleagues, columnists Alicia Finley and Kim Strassel. On Friday morning, a week after hearing oral arguments in TikTok versus Garland, and 2 days before the January 19 deadline facing the app's owner ByteDance, the U.S. Supreme Court issued its decision declining to say that this mandate that it be divested or banned from app stores abridges the First Amendment. Here's a piece of the conclusion of the per curiam opinion, meaning we don't know the specific author of it. The court says there's no doubt for more than 170 million Americans, TikTok offers a distinctive and expansive outlet for expression, means of engagement, and source of community. But Congress has determined that divestiture is necessary to address its well-supported national security concerns regarding TikTok's data collection practices and relationship with a foreign adversary. Alicia, what do you make of this opinion and the distinctions that the court is drawing here with regard to the law that Congress passed, remember, putting this mandate on TikTok's ownership?
It's interesting because they say, or they're very cautious, and they're saying that we address this law with caution because we understand that technology is evolving constantly. I'll quote, as Justice Frankfurter advised 80 years ago, in considering the application of established legal rules to the quote-unquote totally new problems raised by the airplane and radio, we should care not to embarrass the future. So this ruling is very limited in its scope, and it expressly is aimed at the ban on TikTok, or you might say forced divestment. Now, the Supreme Court addresses the TikTok's argument that the law violates its First Amendment speech rights as well as those of its users. Now, there appeared to be a little bit of disagreement on the court whether that the law should even be subject to a First Amendment review. But they said, okay, we're going to assume that it is, that there are some First Amendment rights at stake, and then we're going to review it actually under intermediate scrutiny. So it actually dismissed the TikTok's argument that this should be reviewed under a higher standard, strict scrutiny, which is what the D.C. Circuit actually ultimately did. And the court found that this law is content neutral and also is narrowly tailored to address a compelling government interest, and that being national security. Now, the justices go through all kinds of evidence showing potential for the Chinese government to essentially use the platform to spy on Americans, and just the wide scope of data collection. And under Chinese national security laws, any information and data that TikTok collects, which is really subject to the control of ByteDance, which is subject to the control of Beijing. So there's a lot of evidence in the case record that it uses to base its ruling on. Apparently, the government also submitted some evidence in classified documents, though the justices point out that, well, we are not actually ruling on these classified documents. We're just ruling on the public record. And even so, there's abundant evidence that Congress was motivated by legitimate national security risk. And this wasn't just merely a pretext to supposedly suppress TikTok speech or its user speech. There is no evidence that, the law discriminates against anyone. So I think it's actually a very strong ruling, even if, as the justices say, they're very cautious in addressing it.
There are no dissents on this opinion. A couple of concurrences, though. Justice Sonia Sotomayor has one. She says, I see no reason to assume without deciding that the act implicates the First Amendment because our precedent leaves no doubt that it does. Justice Neil Gorsuch also has a concurrence here tackling a few issues. One of them is this point about classified evidence that Alicia mentioned. Justice Gorsuch says, I'm pleased that the court declines to consider the classified evidence the government has submitted to us, but shielded from petitioners and their counsel, unquote. That has been one of the frustrating things about this debate is there are insinuations about what TikTok may be able to do with its data and so forth, but disagreements about what the actual underlying reality is. And then Justice Gorsuch also says this: I harbor serious reservations about whether the law before us is content neutral and thus escapes strict scrutiny. But then he goes on, Kim, to say that even if it is strict scrutiny, he's persuaded that the law before us seeks to serve a compelling interest, preventing a foreign country from harvesting vast troves of personal information about tens of millions of Americans. And Kim, part of what I find interesting about this is that this was a highly charged case, and we have a per curiam opinion from the court. We don't know exactly the makeup of that opinion, but no dissents on this. There was not even a single justice willing to raise a finger to save TikTok from this national security law passed by Congress, even after, recall, the whole furor of President-elect Trump filing a big amicus brief in this case, saying that I'm the master negotiator and you need to pause this law so that I can get into office and make some kind of deal with TikTok. By the way, the ruling at the D.C. Circuit upholding this law passed by Congress was 3-0, unanimous there, even though some similar disagreement about what the level of analysis, the level of scrutiny ought to be on this law. That was a panel made up of a spectrum of judges, both Republican appointees and a Democratic appointee. So, Kim, despite all of the hot air in the political rhetoric about how the courts are broken and there are justices that are in the tank for one side or the other, this suggests to me, again, it's another example of the justices of the Supreme Court doing their job, looking deeply at the legal arguments, and then ruling on them and basically ignoring all of the hot air in the political arena about this Trump amicus brief and so forth.
Yes, but also being very careful. And I think that that's important with what they did in this ruling, or what they didn't do in this ruling. You clearly saw some discomfort by Neil Gorsuch in particular on questions of the First Amendment. But what was notable about the opinion is that the justices in the per curiam opinion went out of their way to say that there were a number of questions that they were not going to answer with this because they didn't have to in this particular case. You know, one of them was they're skipping the question about whether or not regulations of non-expressive activity do trigger heightened review, for instance. And they said, look, the reality is we don't have to settle all this and have this opinion be an end-all be-all on these vast major discussions that involve, and I thought that there was a certain humility in the opinion, that they said that involve these transformative technologies that are going to be incredibly important to the future, and that meant that the court needed to tread carefully as well, too, and not be setting some sort of wild precedents for future situations that they didn't yet know were coming down the road. So I thought that while it was a decisive opinion, it was a modest opinion and dealt very much with the direct questions at hand. That, by the way, I think is a little bit of a testament to Congress. And I can't believe I'm actually saying this, but, you know, we have a Congress that largely has forgotten how to legislate in so many ways. And the reality is that court opinions often sink or swim on the quality of the product that they're evaluating underneath. And in this case, Congress made it easier for the Supreme Court to be united in a decision here by writing a well thought out law that did not put the courts in awkward positions where, you know, it was a law that was content neutral, that put out very valid reasons for the national security implications of this, and that was clear about what needed to happen and when it needed to happen. And I think that that eased the path for the court to come up with a unanimous decision. We should be seeking for this to happen more frequently.
Hang tight. We'll be right back in a moment. Welcome back. The point about this being content neutral, though there's some dispute about that in these opinions, I think that's an important one to underline, because the gist is that all of the posts on TikTok, everything could stay the same and TikTok could be compliant with the law. What needs to change is the ownership of it, the control of it, whether it is answerable or not to a Chinese company and ultimately the Chinese Communist Party. And so that kind of helped explain, I think, the argument among the justices about whether this even implicates the First Amendment at all. But Alicia, the ultimate fate of TikTok is no more clear, I think, after this opinion than before, because the politicians are, meantime, running for cover. This divestment or ban law is supposed to kick in on January 19th. That is one day before the presidential inauguration on January 20th. By the way, that date, as I understand it, is kind of an accident of the calendar. This law passed by Congress was supposed to take effect 270 days after it was passed. And the way that that falls is January 19th. President Biden, his administration, is now telling reporters that they are not going to make any move to enforce this law on January 19th, one day before Trump takes office. Here's a quote given by a White House official to news outlets. Our position on this has been TikTok should continue to operate under American ownership, given the timing of when it goes into effect over a holiday weekend, a day before inauguration. It will be up to the next administration to implement. Unquote. That next administration is suggesting that they are still interested in trying to make some kind of deal to save the TikTok app for U.S. users. Here is Mike Waltz yesterday on Fox News explaining what President Trump intends to do.
If the Supreme Court comes out with a ruling, in favor of the law, President Trump's been very clear. Number one, TikTok's a great platform that many Americans use and was great for his campaign and getting his message out. But number two, he's going to protect their data. There's people out there who don't want the U.S. government seeing all their data and passwords. We certainly don't want the Chinese government seeing all their data and passwords. He's a deal maker. I don't want to get ahead of our executive orders, but we're going to create the space to put that deal in place.
How many in the first hours, executive orders?
A lot.
Alicia, what do you make of this, and what options does the incoming administration have as it tries to get some sort of deal to save TikTok, given that, as we've been discussing, this is a law, it's been enacted, it's been passed by Congress, it was signed by President Biden, it's the law of the land?
Well, there are a few issues here. As you say, it is the law of the land, but the Trump Justice Department is in charge of enforcing it. Now, there are very steep penalties, up to $850 billion on app stores like Google's an app if they don't remove the app as scheduled or as required under the law. Now, Trump, under the law, also has the discretion to extend a 90-day review period if TikTok has made significant progress on a divestment. Now, that's only 90 days, and TikTok has already acknowledged that, well, it would probably even take more than a year to accomplish a full divestment, and it hasn't even started. There are a number of suitors who are interested in buying TikTok, but ByteDance and Beijing have actually kind of said, well, no, we're not really interested in a sale. Or for one, Chinese government officials say that the algorithms, because it's actually, there are thousands of algorithms that help power TikTok, are actually tantamount to a state secret, and they will not handle or give up control over TikTok's algorithms. And because the algorithms are so intrinsic to the app, therefore, they won't allow a sale of TikTok. Now, in recent days, we've heard leaks, we don't know from where, but that the Chinese government and Xi Jinping, the president, is now considering some kind of deal with Elon Musk that would maybe sell or give Elon Musk some control over the app. Now, I think the Chinese government is essentially trying to coax Trump into a deal that avoids a full divestment. You saw they did this actually in the first term Trump administration, in which they tried to set up a deal in which Oracle and Larry Ellison, who actually founded Oracle and was a Trump fundraiser, would have a review authority over the source code, and all the data would be hosted on Oracle servers. So this, of course, benefited Oracle, but this really didn't mitigate the national security concerns all that much, because even though the data was held on Oracle servers, it still continued to flow back to ByteDance, and ByteDance still controlled the algorithms. Now, in the Supreme Court opinion, it raises the concern or a question that, well, actually, it may actually not be possible for a U.S. company to actually review all the source code or algorithms as long as they are controlled by ByteDance. And in fact, I think this is something that the Biden administration looked into. The opinion noted that ByteDance and TikTok spent a couple of years early in the Biden administration, 2021 and 2022, seeing if they could reach a deal to actually mitigate the concerns without a full-out ban or divestment. And the Biden administration concluded that it was not possible. And so therefore, only a ban or full divestment would be required. Now, I don't see how the Trump administration will be able to mitigate these concerns, again, outside of a full divestment. But I think there's a real concern, again, that the Chinese government will try to play him like a violin and extend the process 90-day window again and again, and maybe settle for something, a quote-unquote deal that falls short of a full divestment and allows ByteDance to keep control of the app.